the inconsistencies. Proctor having it wrapped up in 16 hours, like he didn't investigate anything. And that's sad for John's family. I've also lost a child, her mom. So I know what that's like.
I'm sorry about that.
I know what that feels like. So I feel for her. I do. And I know that it's easy to just blame whoever's in front of you, but they need to blame the investigation.
What does this mean for this community in this moment? Because the community, depending on who you talk to, is divided.
But if you look around, it's really not. What do you see? A sea of pink. You don't really see the blue. And I don't say that they don't have some support, but they're not out here supporting.
I think that they do have a lot of support. You know, I mean, it's a polarized.
They're not showing up.
So what does it mean now that we have this chapter closed? Does it still continue?
Go after the investigation. Hopefully, they'll go after the people that screwed up them not getting justice for their son.
Go ahead, Mr. Jackson.
We're gonna have a problem here. It's the return of the... Oh, wait, no, wait, you're kidding. He didn't just say what I think he did he?
Where the fuck you get off talking to people about me behind my back going over...
And walking around grabbing his you-know-what, flipping the you-know-who. Yeah, but he's so cute, though.
My man James Jackson over there. Buddy, buddy, I'm gonna tell you right now.
Go ahead, Mr. Jackson.
I'm gonna tell you, James, you're good, brother. You're good.
The whole crowd goes so loud, he opens his mouth, but the words won't come out. He's choking how? Everybody's joking now. The clock's run out. Time's up.
James Jackson from the JFK show-off show.
Snap back to reality. Oh, there goes
James
gravity.
Jackson.
Y'all act like you never seen a white person before.
I love JFK. I love James Jackson. I love all of you.
Welcome to Death Row.
Go ahead, Mr. Jackson.
Amen. Wish death for
But I'm here.
I'm here, James
Blood
Jackson.
in my dog and I can't see. I'm trying to be what I'm destined to be.
James Jackson.
My back on the wall, now you gon' see. Better watch how you talk when you talk about me.
Go ahead, Mr. Jackson.
Oh, I got James Jackson. Whoa. Whoa. I'm looking for my hat. It's upstairs. Disclaimer. I got this red hat that I wear. And every
Many men wish death on me, Lord. I don't cry no more. Don't look to the sky no more.
Go ahead, Mr.
And by the
Jackson.
way, I'm seeing someone mention James Jackson in the chat, and I don't know if he's in because I don't have.
James Jackson.
I love JFK. I love James Jackson. I love all of you.
Go
I
ahead,
know
Mr.
I'm missing
Jackson.
people, but
Of
you all
course.
have something.
Hey man, what's up guys? It's Kevin from South Boston. And I appreciate the things that you two do, you and James, right?
Go ahead, Mr. Jackson.
Let's do it.
Let's do it. Go ahead, Mr. Jackson.
James Jackson.
Y'all act like you never seen a white person before.
Go ahead, Mr. Jackson.
Can you guys hear me? Yes, one's in the chat if you can hear me. Check, check. Can you hear me? Yes, one's in the chat if you can hear me. James looks like the boys in my family. Thank you, guys. Thank you. Thank you. Thank you. I will be starting streaming this shortly. It starts at 2. So in the meantime, I just gotta take Lunar out real fast. I know I'm probably gonna lose a bunch of years to that, but I gotta do what I gotta do. So I don't know if I should leave like something playing, but I also don't want to leave something playing that you guys do not want to watch. So I'm gonna try. Court TV had something on, and I don't know if they're gonna continue to play videos or not. Right now, they just have a picture of Karen and their logo. So I will be streaming it. Like I said, for now, I'm gonna just take it because I have a lot to talk about too, about the show coming up on the 24th and everything. So it's gonna be a good stream. We're gonna have a good day. I'm gonna get this done. Fergie, thank you. What up, everybody? So let's see. I would like to say R.I.P. to Francis Gigalotti.
Watching my nephew beg for help.
Top stories. An investigation is underway after a man died while in a struggle
with Haverhill police.
A mother, a family member should never have to go through this. Are we gonna fight?
Easy with that boy. You heard?
Seven police officers holding one and watching my nephew beg for help. And then listening to his last cry. This is a baby that I held in my hands.
We gotta do better than this. 7 cops?
Nobody should have to live through that.
To take down one man?
The DA's office says he had been running through Haverhill, quote, erratically and became unresponsive and later died as officers tried restraining him.
He was running for help. My nephew needed help.
Enos is Gigalotti's next of kin and says she hasn't gotten any answers from police.
Nobody has contacted me. It's like they don't even care. They haven't let us see him. They did an autopsy on him. And we still don't have no information.
Still no information. Does this sound familiar?
I watched a video of a man begging for help. To whom? Not the police.
Has been identified by his family as 43-year-old Francis Gigliotti.
Just wanted to help everybody. And I want people to know that side of him. That, he was a good kid. But he had family that totally loved him.
Man, if we don't stand up and fight for this family.
And this isn't fair.
What can we do? We did it for Karen Reed.
More top stories. An investigation is underway after a man died while in a struggle with Haverhill police. The man has been identified by his family as 43-year-old Francis Gigliotti.
We did it for Karen Reed. We can do it for Francis. Francis Gigliotti and his family need justice. Let's do it. R.I.P. Jigga. We got your back. These cops need to learn mental health is a severe illness. It doesn't take 7 officers to jump on one man. And his last words are, I can't breathe. I can't breathe. Please, I can't breathe.
Go ahead, Mr. Jackson.
We need to do better. Justice Francis Gigliotti.
Go ahead, Mr. Jackson.
Michelle, if you're in the chat or if you see this on a replay, you know, my prayers are with you. I woke up having one of those mornings, you know, where I just didn't understand that my girlfriend wasn't here no more, so I know exactly how you feel. To get back to what I was saying, she told me that he had called her right before everything that happened. He called her and he told her, I think the cops are gonna kill me. Now, he didn't have no run-ins yet. He didn't see the police yet. However he was feeling in his mind at that time, whatever he was thinking in his head, he thought the cops were really gonna kill him. And she's like, chill out. Why are you thinking like that? And so that's what he said to her, and that to me, that's crazy, right? Like, he thought the cops were gonna kill him. So what that tells me is, when they came, already in Francis, in his mind, he already thought that they were gonna kill him. When he saw them, it became more of a reality, like, oh shit, they're here. They're really gonna do something. Nobody wants to talk about it. So then it hit me when I was doing the little thumbnail in the answers. We want answers. It hit me. Maybe people ain't talking about this because it's like my man JFK says, you want to have a beginning, a middle, and an end. Because they got to see Francis's death on, right on TV live, they saw the beginning, the middle, the end. Now all we're doing is waiting to see if these corrupt pieces of shit are gonna be held responsible.
Yeah. Now we throwing down, but I had to do this shit out here. Why am I webbing? But it's going to let us go. Hey man, wanna talk shit on internet? Then you call me homie, and you don't even know me. You see this dude on your screen, think you know.
I had to push the cop aside as I was going, and I want to hold his hand. And I said, Francis, I'm here, even though his eyes were glazed over.
Wanna be some big YouTube star while I'm keeping it real. Hell man, I'm here in my car, fighting the fight.
Investigation is always going to entail the law enforcement reports, eyewitness accounts, any body cam footage.
Right now it's all about Jigga. Fighting the fight, doing it every night. Fight fiction with fact, we ain't pulling no curtain back. It's all about us, no man is bigger. Tell you right now, it's all about
the condition of the actual individual. What level of trauma or crisis were they in? Where there's some type of illicit drugs.
Now friends and family are demanding answers, and they want the Attorney General to step in.
I do believe that Havel PD should be held accountable. I really do think that they do need body cams. This is happening everywhere.
He was screaming for help, and their way of helping him is killing him.
You don't figure that just maybe you're gonna kill Jigga. Fighting the fight, doing it every night. Fight fiction with fact, we ain't pulling no curtain back. It's all about us, no man is bigger. Tell you right now, it's all about Jigga. Fighting the fight, doing it every night. Fight fiction with fact, we ain't pulling no curtain back. It's all about us, no man is bigger. Tell you right now, it's all about Jigga. Hey man, you wanna talk shit on internet? Then you call me homie. Man, you don't even know me. You see this dude on your screen, think you know the real me. Man, you could just blow me. Fighting the fight, doing it every night. Fight fiction with fact, we ain't pulling no curtain back. It's all about us, no man is bigger. Tell you right now, it's all about Jigga.
He was screaming for help, and their way of helping him is killing him.
1 second, guys. I'm sorry, guys. I'm trying my best here. I'm trying my best. I'm a hot mess trying my best. Let's see. But I am working. We working too. We definitely working. What's up, everybody? What is going on? Lynn Diaz, Amy, Little Miss Red Velvet OG, what's up? Yeah, so I will definitely be just bringing this down. I'm going to actually go outside. It's nice. So just give me a couple minutes, guys. Bear with me. I got you. See if I can find something for the beautiful people. All right, well, as you know, we have a show coming up. That's my intro. I don't know if this is the show. 1 second.
Damn, hey, Karashi.
Disclaimer.
But never mistake that Hank Brennan made a lot of money off this Oxycontin thing back in the day because the Oxycontin dealers could afford a lawyer $500 an hour. Explain what a public defender is.
And they do absolutely shit for you.
Shit.
Nothing.
No.
Absolutely nothing.
Absolutely not.
No.
Absolutely not.
Absolutely nothing. At the end of the day, this is a murder trial. She's fighting for her life. She's looking at 20 years, and she's got a judge who's a public defender that knows the ins and outs, and for some reason she took this revenge mindset against Karen. I don't know why, but she's taking all her frustrations out on Karen. And she shouldn't, because if anybody knows how the system is, it's Beverly Cannoni, and I don't get it. Damn, Sando, you see what the fuck they're doing to your boy? You see what they're doing? Damn, Sando, man. Everybody make noise for Sando filming it all tonight. Sando film. Free Karen, free. Free Karen, free. Yeah. Free Karen, free. Yeah. Free Karen, free. Free Karen, free. Free Karen, free. Free Karen, free.
Karen, what can we expect from the defense? Will you testify?
TBD. How long will your case last? 1.5 to 2 weeks. How are you feeling after today? I feel very good, thank you.
Is that the only way you can get his testimony in at this point, if you do?
banter, Karen?
TBD.
Polls coming up. Oh, guys. Oh. Any idea who the first witness will be for the defense?
Dr. Silva.
And you feel that you're going down, this little angel is going to whisper in your ear. He's going to say, "Get up, you son of a bitch! Let's make it love you."
South Boston. Listen, I appreciate the things that you two do, you and James, right? Hey man, what's up guys? Kevin from South Boston. Those two dudes that you're accusing, right? They're decorated dudes. Decorated dudes. And this comes out that she actually did it. Dude. Decorated.
Order in the court. Go ahead, Mr. Jackson.
Your Honor may abstain closing. Reasonable doubt.
Proof that the ATF has no problem killing you.
Hey man, what's up guys? Kevin from South Boston.
What's up, Kevin from South Beach? What's happening?
No, listen, I appreciate the things that you two do, you and James, right? Decorated.
God. One second. What's up, everybody? Let me see. Heard much wasn't happening today, Bob says. Take your time, James. Yeah, I'm trying to be here for you guys and get this going. What up, E-Pags? Oh, man. I'm off for lotion on my face. If I do, someone tell me in the chat. Yes, that's right. R.I.P. Jigga. Let me see. I was upstairs. Oh, Frenchie. Gold. Area code, you Frenchie. I appreciate that. And of course, Becky G. Becky G. Thank you. Hopefully you got a chance to talk with our good friend. I don't know. E-Pags. I don't know if these glasses are gonna. These are those Ray-Bans that they got Bluetooth. I wish I could figure out how to get them connected to the computer. Just go into my Bluetooth. Oh, wait. Maybe it just did. Can you guys hear me? Well, you're going to be able to hear me regardless. Let me try to do this real quick. Oh, really? So she told you what it was like, Becky. I mean, I gave her a little virtual tour. All right, but I want to see if I can connect these real quick, because that would be perfect. Now, mind you, I am outside. Anything can happen out here. Anything is possible when I live stream where I'm at. I mean, the shit can go down at any given time, and I just want you guys to be prepared. If you hear screaming, don't be alarmed. I'm just kidding. Won't be screaming. Better not be. Okay, Bluetooth. Bluetooth is off. Bluetooth is on. Let's see. Let's see. How's everybody doing today? 14 people. God damn. Everybody left. I knew this was going to happen. I should have waited. I jumped the gun. It's okay. She'll be back. Another Quaalude. And she love me in the morning. It's not coming in. It says, God damn. Didn't even shave nothing. It should come up as Meta, right? Meta glasses. I mean, mad. So many things coming up. Let me go back to the top. I got just trying to connect the glasses, so bear with me. Nothing's happening right now anyway. So, guys get to look at my ugly mug. My ugly face. Unknown device. I don't understand it. Maybe if I do this. Oh, baby, I think I might. I did. I think I might have. I think I might have just done it. Then again, I don't think I did. Fuck it. I might not use them. It'd just be easier to hear shit. I don't understand why I don't want to connect to that. Alright, guys, I'm sorry. I wasted way too much time trying to do this. I'll figure it out when I'm not online. You have to hold the parent button on your glasses. Well, let's try that. What? So hold this? I just hear cha-ching. Is it trying to pair? Yeah, it's flashing. Unless, no, I think that's record. Because now it, man, let me see what this unknown device is. Hey, baby girl. Hi, Luna. Hi. You a good girl? Come here. Press connect. If to stop licking me. God damn. Pause if necessary. Yeah, it's not working. I'm not going to waste no more time. Sorry, guys. I tried. I don't think I could take it. Wait. Google it. It tells you, yeah, I get it, Jay Brilliant, but that really isn't a good idea to start, try to do that right now. Oh, wait. I just heard something connect. Nice to hear kind thoughts for Karen. Why? Oh, is somebody not saying kind thoughts? All right, hold on. I need to grab. All right, let's see. All right. Man, just to think about like last year, how much things have changed in a year's time. Oh, you know what I definitely want to go over? Do we have time? We got 10 minutes. I could probably do it in 10 minutes. It's all I need. Is that Lindsay Gattani video. And I could just speak on it real quick and say that I could speak on it, right? And just say this, that she's obviously upset with the police. Oh, wait, they're coming in. I think they're coming in. I hear. I gotta get the plug to plug this in. But she's obviously upset. Oh yeah, they're in. Sorry, guys.
Counsel, I asked the question that you asked, Counsel. He would like to do status first, then the Rule 12s, but he also said to me if you could check your calendars for trial date. All right.
Can you guys hear that?
You let us know we're ready.
Yes, no. Can you hear it? Thank you, Becky. Thank you, Dee Dee. Thank you, Sarah. I think that's Peter Murphy right there, sitting next to Karen's mom. Mr. Reed looking good. He got some color. All right, Mr. Reed, I see you. Oh, here we go. There's Paul. There's Mrs. O'Keefe. R.I.P. John O'Keefe. Wow, that courtroom is full. Oh, there's Jason. I see a lot of people there. I bet you those people went to court today and didn't realize they were going to be in a courtroom with like one of the most highly spoken court cases in a long time. They had no idea what they were walking into today. There's Evan. He's still on. That's good. Oh, is that Jess Machado right there? Yeah, I think that's Jess right there in the front. Yeah.
Good afternoon, folks. Good
afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Uncle Al.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
I'm sorry, did you say the waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor. Attorney General also on behalf of Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Looking Rose on behalf of the defendant, CF McCarthy.
Good afternoon.
Okay, that's all the councilors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all were going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants. That's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days is my guess.
Okay. All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the house were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the house was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead. But
that would be, otherwise it's going to be in a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claim should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there. Okay.
All right, let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for order extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, then.
Your Honor, in a similar vote as to Waterfall, we were putting finishing touches on our discovery responses. The last leg of it is just collecting communications from employees related to the incident, some of whom no longer work for C.F. McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right. Thank you. Let's hear from the plaintiffs then, in terms of the response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
Right, I would expect the courtesy of a meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right, any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took place.
It is, though.
Party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively.
I'm sorry.
We're not
You guys
seeking
hear me?
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that because we're scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Yes,
There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances, we were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying an affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing.
Randy and Ross.
But to have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. We'd like to brief it if the court gives us that permission.
Okay.
His brother did
All
pass
right, on
away.
that last discrete issue, anything else from the plaintiffs?
God damn, Pastor Pepper coming in hot.
We have served them with discovery.
Thank you,
asking
please,
them-
Pastor Pepper.
They have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these 2 cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I certainly am not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence/reckless/intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor, we have the Waterfall. Just very briefly, I think the distinction here the council's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't, from a relational standpoint, close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. It would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No. Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely. You know,
allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iachino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness. At around 6 a.m., they rush to the hospital.
Do you guys mind
It's
if I pause
7:50
this in
a.m.
between and talk about
That's
things?
when the
'Cause
hospital
I think we
pronounces
should.
JJ dead.
Just while we're
And
on the
within
pod, that's what I'm
minutes
gonna do.
of
I'm sorry,
being
guys.
pronounced dead, that's when the O'Keefe
That won't
family
do it.
sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor.
Yeah, I have to pause it in between because, you know, there's a lot of shit this guy's saying. Now, Nan, this is a question I mean, you can answer if you would like. First of all, calling him JJ, why the hell is this guy calling him JJ? You don't know him, man. Call him John O'Keefe. That's number one. Number two, he's saying all this stuff like it just happened. She was just, you know, I get it's a civil matter, a civil case, but how can he say this in open court when she was just found innocent in another court? That's okay? Thank you. Thank you. It's inappropriate. See? It's inappropriate for him to be doing this shit. It's so inappropriate. That's a great, I mean, god damn. This guy, I mean, I don't even like this guy already. Let's see what this asshole has to say.
Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while...
Hold on. This guy just started. Look at how much shit he just said in not even 10 minutes. She hit John O'Keefe. She woke up the niece. The niece is heartbroken. She did all this. She got Turtle Boy against him now. Like, come on, man. Calm the fuck down. Did you drink one of these before you did your little speech? Did you have one of these? I get it. You need to calm the fuck down, sir. Alan Jackson, my uncle, Alan Jackson, is sitting right there, ready to attack your ass. Remember what he says. He doesn't get nervous. He makes clowns like you nervous. Nance said he is allowed to make these arguments in a civil case. Regardless of the criminal action outcome, he shouldn't call him, but he shouldn't call him JJ. I agree, Nan. I mean, I get it. He, obviously he can do this in the civil matter, and this is kind of like where the O'Keefe's, I hate to say it like this, but this is kind of where the O'Keefe's are going to get that satisfaction they've been looking for. We're going to hear things in this case like we didn't hear in the trial that Karen woke the niece up and said these things to her. You know, whether or not Alan Jackson defends that, I'm sorry, something just blew away. Whether or not Alan Jackson defends it, that's another question to remain. Let's see.
Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages. His conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. But the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident, because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of.
Kind of look cool like my uncle.
It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrong.
Nan, so I get it, why they're doing this, but they bring up a case from 1982. You would think that, so this hasn't happened, or a situation or this scenario hasn't happened since 1982, and that's what they're going to go off of, so that's what he piggybacks off of. I get that they just keep piggybacking off of cases. I think they should remain in the case. Like you said, the plaintiffs were not there. It doesn't matter. The plaintiffs were not there at the scene. So it's almost like saying it doesn't matter about whatever case you're talking about in 1982. That's not the same case as this case. It's just civil matters and court matters and all. It's just crazy how they piggyback like that. And that's how they keep a crooked system rotating and spinning. Because if they keep getting away with it, I mean, luckily here we stopped it. We threw a fucking wrench, we shut it down. But the corruption is there. I don't think they should piggyback off cases. Her being innocent has nothing to do with dismissal of this case. I get. Even if the case is from 1982, it may mean that the 1982 case is still good law. We often use old cases to support our positions. And that's what I get that. So it's a standoff move. It's a strategic move too, because if you're getting buried, you can say, well, Your Honor, in 1982, there was this case where a man was found innocent, so I get it. There's a yin and a yang to it, I guess, like everything else. But thank you, Nan. Your insight is always, it's always, everybody in the chat here is always happy to have your insight. Thank you. We appreciate it. Let's get back to this piece of shit.
There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body.
She still learned of it,
Contrast
though.
that with everything that we talked about, Your Honor, where
She still learned. She still learned of it.
Knowable, they learned about it. They rushed to the hospital. They saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one.
Let me say this, since this is why I like to do these. I should do this more often because I don't lose track. I am not taking nothing away from the O'Keefes and how they feel. I know they are going through it. The children, Mrs. O'Keefe, Mr. O'Keefe, Paul O'Keefe, his family, his friends, his loved ones. So, disclaimer, I'm not taking nothing away from how they feel. But this guy, I am going to take away a little bit from him. His credibility and the way he's delivering this is, you know, and then to look at Karen and see her reaction. I feel bad. Karen's just sitting there hearing all this. And I know AJ, wait till AJ attacks. Like, you know, Becky said, it's not possible they all drove by where John O'Keefe supposedly was laying, right? And that's true. We already went through that. But wait till AJ comes in. So I just wanted to throw that disclaimer up there. I am not taking no feelings away from the O'Keefe family. Let's carry on with this piece of shit.
I want to talk briefly about Kaylee and her NIED claim. To suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure The third that she has now lost was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own two eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody.
I mean, if that was the
Third,
case,
Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct
look at the
would be
CEO. He's like,
detrimental
I can't
to
believe
these
this guy's
vulnerable
spitting this
plaintiffs.
shit out.
And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's
I zoom in on her hands.
is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her. knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the
Because now I'm going to say, stop you right there. What you're doing, you're bringing Turtle Boy into this, and you're saying he leaked this and did this and said this and fair game and da. Now you're acting like the pain is coming from what he did. So is there emotional distress from JJ that you keep calling him, John O'Keefe, passing away, or is it from Turtle Boy being bad on the internet? Get your shit together, man. Sorry, Nan. To leak public information through Turtle Boy. Well, see, I didn't even read that yet, and I was just going in. Exactly. So that's exactly what I'm saying, Nan. So is it Turtle Boy that hurt your feelings, or is it Karen? You can't have your cake and eat it too. This guy's trying at any cost to win, actually, and I get it. That's his job. He has to win, right? That's what a lawyer wants to do, because he's gonna get his share. And but still, god damn. Let's get back to this asshole.
extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability. And yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family. And a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely
Don't worry, we're
within
with you, Karen.
any other case decided on this
You're not the
issue,
only one listening.
remember the
That's
facts
it.
and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases they cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires
Don't
us to
forget the
decide
glare.
this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it.
Who else
Counsel
likes
didn't
this
tell
guy's
the court
accent?
is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. You also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it, but nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. And what you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here, clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case, realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench that's been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately, that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell
What he's also, hold on one second, I'm sorry. What he's also referring to there is they could settle this before even going in front, not just like have a mediator and try to discuss this and have Karen talk with the family and say, you know, I'm sorry or whatever the hell. It's not a mediation like that. It's like basically talk with your lawyer and see if you guys can come to some agreement. Whatever they're asking for, you know, let's just pay them out. And then this doesn't even have to go in front of court. And who knows? And Paula made a good point. I think it was Paula. Or, no, I'm sorry. I think it might have been Barbara. I'm sorry if I got it wrong. It was either Barbara. I'm pretty sure it was Barbara. But she said, I guess we know now why Karen has kept her distance from TB. And you know, I knew this. We knew this, is what I'll say. And yeah, you're right. That's exactly why she is probably doing that, because now his name's coming up in this civil matter. It's already come up probably, I'd say at least 20 times that guy said TB's name. I mean, it could be no more. He said his name a lot, is my point. So that's a very good point. Very good observation, Barbara. And I think so too. The judge seems pretty fair, though.
tell them all about things like the time it takes to get to litigation, how what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have two ongoing, as far as I understand, the two businesses in Canton are ongoing, and they have their business decisions they have to make ultimately. They're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do it by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do what.
We're agnostic? Is that what you said?
Yeah.
Agnostic?
We'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Oh.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here at Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
How many days out you want to go for? 60 days, 90 days?
Yeah, probably 60 days.
50 days? November 21st, Friday in the end of November.
Yeah, that
Well,
November
Mr. Reed,
21st.
he could have sat home and
I'll
did
have a
these
decision
on
out
his
before
Zoom.
then, certainly, as quickly as I can. 11/21.
Yeah, Becky.
And that would be for a status regarding tracking order and discovery and any motions.
They can't make her.
Rule 15 motions to amend or bring in third parties.
But
okay. All right. Thank you, folks. We'll see you then.
Thank you, Your Honor.
oh, let me just.
All right.
Karen's looking good though. She's smiling. She's happy. Yeah, in their own way. Let me just check this out. Yeah, so they could make. They definitely could make her. I mean, they don't have to. I'm sorry. Disclaimer. They don't. They can't make her do anything. She could take this all the way, all she wants. And to be honest, I think she really wanted to be on TV because I mean, I think she wants to go because it's being covered. And absolutely, man. Thank you for being in the chat and answering questions that came up. And it's always a great help. So thank you. But so Nan, you could maybe answer this question too. They can't force her to settle, right? But she might just do it just for to get it done, like to get it out the way. I mean, some people cop out to please that. Like we just talking about this a couple days ago. A plea that I copped out to that I didn't want to. But my point is, she could do this just to move on with her life. I think. Anyway, right? No, they can't force her, but I'm saying she could settle out of court. That's what the judge was saying, basically. That's what I got from it. No? Like there's other ways. He said there's mediation, and I don't think he's talking about mediation like, oh, you guys go downstairs and talk to a mediator and become friends again. I don't think he meant that, obviously. I'm just trying to change his background. I mean, it's black, whatever. I just want to see something. That's better. All right, there's a lot. So Becky says, I think they also want to force all those people to testify too, though, to get in what Bev wouldn't allow. That could happen. I mean, that's gonna happen. She won't settle at this point. Not if she is adding the McAlberts and the law enforcement as parties. Well, I don't think so either. I don't think she'll settle at this point anyway. I mean, Karen just seems like the type that is going to fight no matter what. After everything they put her through, I think she's going to fight it tooth and nail. She's not going to just say, okay, here's 50 grand or whatever they're asking for. Like, isn't it only like 50 grand? I don't know how much that they're asking for. I thought I heard somebody in another chat talking about it, but they're trying to sue CF McCarthy's too, and they're trying to sue the waterfall, or was it just exactly, James? I had to settle a civil case very recently. Vipers, it takes over your life and your finances. Yeah, so that's what I'm saying. She may just want to move on with her life and say, here, if she has the money. But I don't see her doing that only because of where her career, like financially, where she's heading, I think she's going to be starting to head towards a direction that, this is content. Like when we go to get content, this is content for her. She's going to have book deals, movie deals. This is all going to be part of the content for the movies. This is, look at it like this. This is just B footage basically. And when that movie comes out, this might be something that they add to the movie. Uh-oh. Luna just took off like a bat out of hell. Probably a rabbit. Poor rabbits. But I mean, if that's the case, I just hope that I don't know. I just hope that this doesn't take another 2-3 years. Look at Mr. Reed, man. This guy, this poor man, he's been through so much in the last couple of years. I mean, Karen too. Disclaimer: Mrs. Reed, Karen, all the Reeds, the O'Keefes, everybody. That's a lot. Court is nothing but stress. You sit there all day. You got the especially when for Karen, she sits there all day. She's looking at life in prison. Even though people tell you, you got this, you're gonna be all right, you got this. Yeah, that's great. But you don't know. Like, for instance, my friend, I'll tell you real quick a story. My friend had to go somewhere today to another state for a federal hearing. And he texted me this morning to let me know that he was going inside the courtroom, that he wanted to take my number down. I'm sorry. She's fresh little girl. But so he texted me and said, I took your number down just in case I have to call you. I wrote it down basically, because when you have your friends' numbers in your phone, I don't remember everybody's number. I just go to their name and hit send. So, that's like when we saw that video the other day. We were watching the breaking down the booking video, and they asked her, "Do you have your lawyer's number?" And she said, "I know it by heart." I mean, I used to know all my lawyer's numbers by heart, but I don't no more. I don't have to, and but it's stressful, very stressful, for sure. So, do you guys want to watch that video? I mean, we've already been rocking for like what, an hour and a half, because I wanted to just talk about it. Because Barbara, was that you that brought up that save the bunnies? I can't save them. There's nothing there's literally nothing I could do. It's so funny because like I would tell JFK and I'd talk about it during the live streams, how Luna chases bunnies and shit. And it just sounds like talk, right? And then when he first landed, he came and we took her for a walk, and she saw her bunny and she got out of her harness and she took off, and like this was like the second time she's ever got away from me, like took off, and I was so scared. My heart's pounding, and he's I just started running after her, and he's at the top of the park, like the hill, just looking like, what the hell? I'm like, yeah, man, it's like that. I told you she was crazy. Feed the ducks? Oh, goddamn, that shit was crazy, huh? I can do that for you. I can feed the ducks, man. I mean, goddamn. ST was a good sport. I said, I don't know how, like, I never realized, because I scroll by that all the time, the songs, like the playlist, because, JFK will send me music. And so I'm like, did he send me this video? And then I thought it was going to be a video of her feeding the ducks, but no, it was just the instrumental. But yeah. So Barbara, was that you that said this is why? I'm sorry, I've been all over the place. This is why she's now or was it Paula? This is why she's probably not talking to TB right now, and why she's staying clear of him because this this attorney brought him up so many times, and it's like I said, I don't know this attorney's name, but sir, you're saying your client has mental, not mental distress. Yeah, I guess mental distress, emotions, or what is it? Emotion. I don't know what the claim is. Emotional stress from a death. But then you're saying, and then Turtle Boy, well, TB, attacked them and told everybody it's fair game on them, and they were attacked by everybody. All right, now you like, do you realize how many people outside that courtroom when Karen Reed was found innocent? So you gonna bring all those people in as witnesses? Because I'll tell you right now, there's not a goddamn courtroom in the world that could fit all those people. And I mean, I don't know, he was kind of all over the place, and that's why I think her new attorney, someone said he was from South Africa, the guy that got the slick accent. I like him. Him and AJ, him and my uncle they're gonna do good together. They're gonna do real good. Was it you, Paula? Which one? No one's saying who it was. At least she doesn't bring you little bunny presents like my little shit. Oh no, she don't bring them to me. I have to chase her and get them away. Get them. Well, one time I had to get one out of her, and it didn't die, so that's a good thing. But yeah, man, he just brought up a lot. So yeah, and then her attorney says we're gonna address all those accusations that he just said, and we're gonna speak on all those claims when when this starts rolling. We're not gonna get into all that right now. This guy needs to calm the fuck down. This is basically a motion. That was the first day she was at the first. Yeah, it's the first hearing. Come on, man. This guy tried to show his whole hand the first day. It was Barbara. Thank you, Paula. Barbara, I guess Barbara don't want to take Barbara, I was saying that was a good Barbara's scared to say it was Barbara, it's okay. Nobody's gonna mess with you. It's okay. Okay, oh, she came in right now and said, yeah, it was you, Barbara. That was a great point. Yeah, E-Pags, I saved the Easter Bunny. I didn't save the Easter Bunny's life. I saved the little baby bunny's life. Easter Bunny's kids. Barbara, yeah, that makes sense. I mean, I kind of knew. I kind of had an idea. And, I just don't want to blurt shit out. But I kind of had an idea. That's, like, kind of why she wasn't. But, it is what it is. She has to protect herself. I mean, but at the same time, TB's facing 5 years. So I don't know. I do know this though. I do know this. Hold on. Oh yeah. What? What time is it, E-Pax? Oh yeah. Don't fight it. Pause if necessary. Just hey, took too many. Only one. God damn. It's that time. Oh yeah. It's that time. Gentle. Give you a kiss. Thank you, Ducky. Thank you. God damn. God damn. Feeding the ducks. Yes, we are feeding the ducks. Feeding the oh shit. Nothing like feeding the ducks. Nothing beats feeding the ducks. Here we go. What's that? In case you forgot. You hear them? I wish I had a duck. You know what? Yeah, this has been good, guys. I'm glad we got to do this. I tell you right now, if they're gonna start doing these on camera, as they said they were gonna do, let me shut this off. All right, we fed enough ducks. You guys full? See you later. Pack it up, ducks. I will be covering the case that I will be covering the civil case until it's finished. So I know they got Melanie Little and who else? Who else does Young Jerks? Our boy Money Making Mike Crawford and Melanie. I have to go on there and show her about my skin routine. She said it's gonna be a really fast show because my skin routine is very basic. So she said I could go on there and do a skin routine. All right. Hey, whatever I gotta do. Let me get to these super chats so I can thank the beautiful people. Frenchie, I got goals. Thank you. Frenchie, I appreciate it. Becky G coming through with the God damn the umbrella. It's windy here. Becky G coming through. Thank you, Becky G. Appreciate you. E-Pags, I always liked when you aired the trial. Thanks, James Jackson. Thank you, E-Pags. And like I said, I will be doing more. Please, Pastor Pepper, thank you for 99. Please, Pastor Pepper with the big dog $100 chip. E-Pags. Afternoon magic. Yes. Well, we got to talk about the decoration. So that's how I just want to end this real quick with October 24th is the show. I'm sorry. October 24th is the show in Malden. It is at 75 Meridian Street, Malden, Mass. And so far, let me see. I just had a flyer that I'm making because we working too. We do everything ourselves. So far, it's gonna be. I'll have to send this to you, Becky and EPAG or EPAG. So I don't know if you can see this. Oh shit. Anyway, it'll be up. I'll send it to you. What the hell, my phone just died? Oh man, it did. That's alright. So hold on. Let me just plug that. Sorry. All right. So I'll see you. Yes. DB, the other thing too I was going to say is YouTube. I don't know. A lot of YouTube creators have been saying this, and I checked on it today. If you're not subscribed, subscribe. Or if you are a subscriber, it's been like kicking people out. And if just make sure you're still subscribed, make sure your notifications are on. And like I said, we'll be doing this one whatever time this is, like 2 o'clock. Usually, actually, I don't know. I think these civil hearings, they're not. I don't. Sometimes most of them are. I think in the afternoon. It's pretty weird that they're doing it in Plymouth. I wonder why they're doing it out there. If Nan's in the chat, maybe she knows if she's still here. But you know, so that's what I was saying. October 24th, 75 Meridian Street, Malden, Mass. Now the next thing is going to be tickets. I talked with the people that are going to be helping, and we're going to figure that out. So probably by, I'd say tomorrow, we'll have like the ticket price and where you can get the tickets and all that. Where you can get your ticket, however you want to do it. But it's going to be great. It's going to be me, JFK, Kevy Kev, Young Jerks, Mike Crawford will be there. Nan, of course, will be there. And I guess someone said Aunt Deb was going. So that's going to be cool. And the other thing is, this place that we're going to be at is so close to where TB's having his party. So I'm sure people are going to go from place to place, You know, it's not just going to be, I don't know. I think it's going to be another good night. And I think if you are close and you're local and you can get out here and you can make it, then make it. Replay crew, we love you too. We got goals, as you see, going across the bottom of the screen. James Jackson, JFK Show Off, Kevy Kev, Cash Apps open 24 hours because we working too. I actually have to go. God damn, these birds are loud today. Sounds so yeah, if you're local and you can make it, if you're going to TB's event, the Halloween party, and you want to swing by after, you know, that's cool. Oh, the birds are so loud. I'm sorry. That's probably why everybody's leaving. They are. I mean, I normally don't go outside and do it. It's okay. I normally, cause but yeah, if it's too loud, I mean, I've already been going for the 2 hours, so I'm about to end anyway. But no, we fed the ducks, Becky G. God damn. There's a baby girl. You gotta let the air out. Oh, I'm sorry. I'm sorry. I got this song. I'm sorry. Yeah. They sound. It sounds like a crow. There's probably a hawk around here. There's always hawks. I always see big ass hawks, and then the crows scare the hawks. Isn't it funny how crows are the only ones that stand up to hawks, and a hawk would rip a crow apart if they really fought? Yeah, exactly. Oh, I thought you meant keep the dogs away from each other, separated. But all right, everybody. I hope that everything is all set with the flyer. I hope that we can have the tickets done by tomorrow. I'm gonna work on that today. I'm gonna go down and get the tickets ready. I have a lot of stuff to do because we working too. We working all the time. But it's still justice for John O'Keefe, right? R.I.P. John O'Keefe. R.I.P. Francis Gigalotti. Justice for Kelsey Fitzgibbons. Fitzgibbon, I don't want to say her name wrong. And just everybody that has lost somebody. But let's go. I'll see you guys on the next layover.
Watching my
Sorry about that. Peace.
watching my nephew beg for help.
Top stories. An investigation is underway after a man died while in a struggle with Haverhill police.
A mother, a family member should never have to go through this. Are we gonna fight?
Easy with that boy. You heard?
Seven police officers holding one and watching my nephew beg for help. And then listening to his last cry. This is a baby that I held in my hands.
We gotta do better than this. 7 cops
Nobody should have to live through that.
to take down one man?
The DA's office says he had been running through Haverhill, quote, erratically and became unresponsive and later died as officers tried restraining him.
He was running for help. My nephew needed help.
Enos is Gigalotti's next of kin and says she hasn't gotten any answers from police.
Nobody has contacted me. It's like they don't even care. They haven't let us see him. They did an autopsy on him. And we still don't have no information.
Still no information. Does this sound familiar?
I watched a video of a man begging for help. To whom? Not the police.
Has been identified by his family as 43-year-old Francis Gigliotti.
Just wanted to help everybody. And I want people to know that side of him. That, he was a good kid.
Who else?
But he had family that totally loved him.
Man, if we don't stand up and fight for this family.
And this isn't fair.
What can we do? We did it for Karen Reed.
More top stories. An investigation is underway after a man died while in a struggle with Haverhill police. The man has been identified by his family as 43-year-old Francis Gigliotti.
We did it for Karen Reed. We can do it for Francis. Francis Gigliotti and his family need justice. Let's do it. R.I.P. Jigga. We got your back. These cops need to learn mental health is a severe illness. It doesn't take 7 officers to jump on one man. And his last words are, I can't breathe. I can't breathe. Please, I can't breathe.
Go ahead, Mr. Jackson.
We need to do better. Justice for Francis Gigliotti.